Assalamualaikum warahmatullahi wabarakatuh. Thank you for giving me a chance to explain my paper, which title is The Journey of Human Rights During the COVID-19 Pandemic in Indonesia. In the year 2020, the world is being hit by the outbreak of coronavirus disease in 2019, or we call COVID-19. The victims of COVID-19 is certainly almost increasing over time. This certainly became very dangerous so that many countries have finally locked down their own country for the prevention of the removal of the COVID-19 virus. However, in Indonesia doesn't do lockdown but rather a large-scale social restriction. In addition to triggering victims of COVID-19 virus, it is threatening to all sectors of both economics, tourism, social, and agriculture. Besides, this threatens its own human rights, which many people do not fulfill these rights. Among these are many workers who have been fired or carried out a mass terminations of employment by the company. Other cases were discriminations by citizens against the COVID-19. This is a certainly very serious problem in which the rights of one must be affected by it. Looking at the problematics, it has become the right of all people to acquire the right that should be possessed, which, if those rights are forfeited, then it will create a peaceful and serene life. If this happens continuously, it will destroy the country because the state is not able to bring safety and freedom of the individual. Based on the method that has been displayed, they can be taken a formation of a problem as follows. First, how is the regulations that guarantees human rights in Indonesia? Second, what are the problems by running of human rights that occurred in Indonesia during COVID-19 outbreak? Third, how to reduce human rights barriers so that they can be carried out during the COVID-19 outbreak. As we know that human rights are set of rights inherent in man as a creature of God Almighty that must be protected and appreciated by every human being. For this sense, human rights have their attributes as essential, universal, permanent, and cannot be shared. Thus, human rights will always be attached to it. Therefore, social contracts certainly answer human rights. It is outwardly an obligation when it comes to forming a country. By ensuring human rights, the country can provide a safe and secure life for all people living in a country. That, that is what the basis that I thought for making this paper. And there is a later studies that I used as the basis for making this paper too. And the first is the journal titled Perlindungan Hak Asasi Manusia dalam Negara Hukum Indonesia, written by Eko Hidayat. His writing discusses what human rights are, the story of human rights protection, and how the state formed the law itself. The second, the journal titled Penerapan Prinsip Negara Hukum, written by Haposan Sialagan. In his writings, he concluded that in the principle of human rights protection law, the separation or division power, the implementation of sovereignty of the people, the existence of government based on the prevailing laws and regulations, and state administrative judiciary. The third, the journal titled Perkembangan Hak Asasi Manusia atau HAK or HAM dalam Hukum Indonesia, written by Ratna Kumalasari. In her writing, she concluded that the development of human rights management in Indonesia law has evolved for the better. This signifies normative respect and recognition of human rights by the state. The fourth, the journal titled Dilema PHK dan Potong Gaji Pekerja di Tengah COVID-19, written by Muhammad Anwar. The writings discuss the many occurrences of termination employment and cut salaries during the COVID-19 pandemic. The last, the journal titled Hapus Diskriminasi sebagai Upaya Melawan Stigma Coronavirus Disease or COVID-19, written by Fadhli. The discussion of journal that a negative stigma to COVID-19 occurred due to lack of knowledge of society, which was natural because the sudden outbreak of the plague. There is a research method that I use for making this paper too. This type of study is a normative judicial, or also known as doctrinal law research. The method used in the study were, first, Statute approach relating to Constitution 1945 and Act Number 39, the year 1999 on human rights. Second, case approach related cases of human rights not fulfilled in every human being. This research technique uses research, search, and analysis techniques conducted through data collection through a library research method consisting of books, scientific journals, mass media, and internet as well as other relevant references. The next slide is about the discussion of my paper. First, as we know, Article 1, Paragraph 3 of the Constitution Indonesia 1945 mentions Indonesia as a legal state. If it refers to unappealed opinions that the purpose of the law is for fair and peaceful order of the community, the consequences of the statement is that all acts of state life must conform to the supremacy of the law, in which every action is legally accountable in the absence of irregularities and misuse of the authority. The action of the country that can be accountable legally will create an orderly and prosperous country. According to Sudargo Gautama, the elements that must be owned by the law state. There is a restriction of state power to the individual, the existence of the legality principle, and also separation of power between institutions. So, in the absence of irregularities to create an orderly and prosperous state, Indonesian law should have a guarantee against human rights, separation or division of power, the legality of government, free and impartial administrative judiciary, and the realizations of the public welfare of citizens. Speaking to the requirements of the human rights guarantee with a glance at the legislation of Indonesia state has answered the progress of human rights in the Constitution of the State Indonesia 1945. As a form of decline in the Constitution Indonesia 1945, which is the constitutional state, Indonesia also made law that one of them is Act Number 39, the year 1999 on human rights. Although there is already setting on protection of human rights at the time of Covid-19, human rights in Indonesia have become hampered, so it is not fully in giving human rights they should get. The first problem is that there is an obstacle to the right to work in which the layoffs occur on a large scale. According to a statement from the Director of the Ministry of Manpower Development, Siti Kustiati, as many as 13.9% of the company reduced the number of the employees. One of these events can be taken is the mass layoff by the Gojek Indonesia company, which carried out a layoff policy for 430 people, which was due to the corona pandemic. Apart from Gojek Indonesia, the company that has made layoffs, namely Traveloka, which involved 100 people or 10% of the number of employees of the company due to the corona pandemic, in which demand for hotels, restaurants, and travel tickets decreased drastically. Seeing all these elements, the right of every person to work and get a job as it has been guaranteed in Indonesia Constitution. This led to the breaking of the search for the survival of the people because it could not provide for his life. In addition to obstruction of the right to work, there is an obstacle to the right to be equal, where there is an incident of refusal to nurses by the boarding house owner, which results in three nurses being unable to return their boarding house and having to stay temporarily in hospital. It was done because the owners of these boards fear going against the owners of boarders and their families. Similar case also occurred during the time of COVID, where doctors and nurses coronavirus patients were rejected by residents around their homes because the fears of citizens contracting the virus. The stigma done by the owners of the borders to the three nurses and the experience that happened by that happened by doctors and nurses was due to the was due to their extraordinary fears that the act of discrimination occurred that met in violations of human rights owned by the three nurses and as human beings. From the description of this case, we as humans must uphold the rights of others. It has become our obligation as an Indonesian citizens to always respect and safeguard the rights of others in order not to be damaged. But seeing the situation in this plague is also very inevitable because the impact of this plague is so great. This just becomes problematic experience in the pandemic plague of COVID-19. In order to achieve peace in the country's life, it is the duty of state to ensure the rights of its citizens by giving a legal umbrella. The nation has provided legal umbrella against human rights to protect from unwanted things. For application, the law enforcement is required to run it firmly, so that the prevailing legal norms in Indonesia sheets of are not only sheets of papers that do not have. However, for the sake of implementing guarantee of human rights, the country cannot do it alone. So Jonas Sokanto in his legal effectiveness theory argues that a law can be said to be effective or not dependent on several things, namely the legal factor itself, law enforcement, facilities or amenities, the community environment, and cultural factors. Thus, by looking at all these elements, is a barometer in determining how effective the legal norm applies to people's lives. The five elements of the effectiveness of the law are interconnected to each other, so that it becomes a condition that must be supplemented in the running of a rule. The COVID-19 outbreak caused the establishment of a human rights enforcement process which had become an obligation by the law enforcement. We cannot violate each other for the disappearance of human rights not acquired by people due to COVID-19 pandemic. As a form of regarding human rights, the government and the community must shoulder each other in enforcing human rights to complement each other's deficiencies and find the right solution to overcome the problems faced in obtaining the rights. Thus, the barometer that becomes an effective measure of human rights assurance can be run properly and securely. Based on the extension of this discussion, we can conclude that Indonesia can understand as the country of law state in the constitution has been to ensure human rights owned by everyone. Human rights assurance is a consequence of any action undertaken by the state should not arbitrary and must be applied to the law. Therefore, in order to create a guarantee that there's only nonsense Indonesia to ensure human rights as stated in the Constitution of Indonesia 1945 and derivative regulations of the Act number 39 in the year 1999 on human rights. The journey of human rights at the time of COVID-19 suffered considerable delays. It can be found by many people in layoffs because of the COVID-19, which weakened business activities. It is also loss of the right to work as it is secured in the legislation. Moreover, it found discrimination against medical officers for fear of the COVID-19. This becomes a waiver of the right of equality that medical officers should be obtained. So Jonas Sokanto's legal effectiveness theory presents 5 points that are factors of the law itself, law enforcement, facilities or amenities, the community environment, and cultural factors. All of them must be possessed in the running law. Thus, to reduce the likelihood of undoing human rights insurance, the need for mutual action by all parties in enforcing human rights amid the COVID-19 outbreak. Advice that the authors can give on this matter is the involvement of state institutions and public institutions that cooperate with each other in monitoring the development of human rights in the middle of COVID-19 pandemic and finishing in coordination to relieve the burden of the rights that should be obtained by the public. Thank you for your attention. Assalamualaikum warahmatullahi wabarakatuh. Thank you everyone.